चलिए आगे बढ़ते हैं। एक ऐतिहासिक आदेश में सुप्रीम कोर्ट ने जेल के ऊपर जमानत के महत्व को दोहराया है। कानून के सिद्धांत पर ध्यान देते हुए सर्वोच्च न्यायालय ने कहा कि लोकतंत्र कभी पुलिस राज्य नहीं हो सकता और केंद्र सरकार को निर्देश दिया कि सरकार अनावश्यक गिरफ्तारी से रोकने के लिए कानून बनाए। बेंच ने ब्रिटिश सरकार के समानांतर चित्रण करते हुए कहा कि गिरफ्तारी एक कठोर उपाय है जो स्वतंत्रता को कम करता है और भारत की मानसिकता को प्रदर्शित करता है। हरीश हमारे साथ फोन लाइन पे जुड़ रहे हैं। हरीश, एक अहम फैसला कोर्ट की तरफ से, क्या कुछ कहा कोर्ट ने?
Yes, the Supreme Court has said democracy can never be a police state. Saying so, the Supreme Court has stressed the importance of and issued guidelines to prevent unnecessary arrest and remand. Supreme Court has reiterated in an order to avoid unnecessary arrest, jail be an exception and bail is the norm. Supreme Court has directed government to restrain investigating agencies from arresting accused in various cases unnecessarily, saying that indiscriminate arrest reflects a colonial British mindset and creates impression that the country is a police state. In a landmark judgment, the Supreme Court has stressed the importance of rule bail over jail and issued a slew of directions to prevent unnecessary arrest and remand. The Supreme Court has said jails in India are flooded with undertrials. Jails, the statistics placed before us would indicate that more than two-thirds of the inmates of the prisons constitute undertrial prisoners. Of this category of prisoners, majority may not even be required to be arrested despite registration of a cognizable offence, being charged with offences punishable for 7 years or less. They are not only poor and illiterate, but also would include women. Thus, there is a culture of offence being inherited by many of them. So, Supreme Court has, after making these observations, issued several guidelines and said all state governments, union territories, and high courts are directed to file affidavits / status reports within a period of 4 months. It noted that, number one, noting that jails in India are flooded with undertrial, Supreme Court remarked that bail applications ought to be disposed of within a period of 2 weeks. Applications for anticipatory bail are expected to be disposed of within a period of 6 weeks, with the exception of any intervening application. Number three, government has to consider introduction of a separate enactment in nature of a bail act so that to streamline the grant of bails. Number four, investigating agencies and their officers are duty bound to comply with the mandate of Section 41 and 41A. That is, no automatic arrest. Reason has to be laid down in writing, and any direction on their part has to be brought to the notice of the higher authorities by the court following the appropriate action. So all state governments and union governments have been directed to facilitate standing orders for the procedure to be followed. And last, state and central governments will have to comply with the directions issued by the court from time to time. The High Court, in consultation with state governments, will have to undertake an exercise on the need for special courts have to be set up to dispose of cases fast. So these are some of the guidelines issued by the Supreme Court to prevent indiscriminate arrests. Back to you.
All right, so guidelines issued there to prevent indiscriminate arrest. Thanks very much, Harish, for joining us with those details.